and good day to our distinguished ICMA members and executives, industry professionals, ladies and gentlemen that have dialed into this webinar from all over the world. It is my great pleasure on behalf of the Ghana Stock Exchange and ICMA West Africa Regional Committee to welcome you to today's very, very topical webinar. Our webinar today seeks to provide practical guidance on the use of the Global Master Repurchase Agreement, GMRA, in following ICMA's recent issue of a clean legal opinion on the GMRA for Ghana. Today's webinar has been packaged to benefit not just our African capital market participants, but also capital market participant professionals across the world. We recognize the critical role repos play in the efficient functioning of Africa's debt capital markets, such as the Ghana fixed income market. Repos not only provide liquidity, but also offer a vital mechanism for managing credit risk, enhancing market stability, and supporting the broader goals of economic growth. Central to this framework is the Global Master Repurchase Agreement, a powerful tool that facilitates standardized, transparent, and enforceable repo transactions across jurisdictions. Today's webinar, ladies and gentlemen, is timely as we continue to witness the evolving dynamics of capital markets, particularly in emerging economies. After using collateralized repos for over 2 decades with its associated risks, it is time for our markets to evolve fully into the adoption of repos under GMRA, which was launched in Ghana in 2019. Today's webinar will help us to understand the practical steps used to transact repos under GMRA. Ladies and gentlemen, today's webinar is yet another example of ICMA and the GSE's commitment to capacity building, market development, and innovation. We remain steadfast in our vision to transform our markets into globally competitive and well-regulated platforms that serve both local, regional, and international investors. I encourage all participants to actively engage in today's discussions, ask questions, and explore how the principles and practices shared here can be adapted in your respective markets. Once again, I commend all speakers and especially our expert, Richard Komoto, who's joining us today to share a lot with us, and our participants for devoting your valuable time, and wish all a productive and insightful session. Thank you very much for your attention. And at this stage, I'll hand over to Dina, who's an associate counsel at ICMA, for her remarks. Thank you.
Thank you, Abner. Hello, everyone, and thank you for joining today. So I'm Dina Saudi, a Senior Director and Associate Counsel here at ICMA. So I cover all things repo from a legal perspective here, and in particular, the Global Master Repurchase Agreement, so the GMRA. So one of my primary responsibilities when it comes to managing the GMRA is commissioning and updating the ICMA GMRA Legal Opinion Library. So ICMA currently provides over 70 legal opinions, and last year, as Abner said, we were very pleased to be able to expand coverage and include Ghana in our offering. We worked alongside law firm Bella to produce this. The resulting opinion was very well received by our members, and we hope marks the beginning of broader coverage across Africa and more regions. Providing our members with sufficient legal certainty regarding the enforceability of the GMRA is one of the most valuable services that we offer in the repo space here at ICMA. For many market participants, legal and regulatory requirements mandate that they must have access to opinions such as these. So whilst talking about the legal opinions, I thought it would be helpful just to provide a little bit more context and insight into our legal opinions and how they work. So as I've said, our legal opinions cover the GMRA's enforceability and cover both the 2000 and the 2011 versions of the GMRA. So access to the legal opinion library is exclusively available to ICMA member firms via a subscription. Our legal opinions all follow the same structure. They have a basic or an extended coverage that all counsel will use. Typically, they will cover and be consistent across jurisdictions in this coverage, companies, banks, securities dealers, insurance companies, hedge funds, mutual funds, and in some cases there may be a jurisdiction-specific entity, such as a government pension fund, or there may be an even more specific entity coverage, depending on what our members are asking for and sort of demand. As I say, the core focus of the GMRA legal opinions is the netting provisions. So overall, the validity of the GMRA, and it will also address the recharacterisation risk. As you may know, the GMRA operates on a title transfer basis for both the securities and the margin. So the primary reason that our members will use the ICMA GMRA legal opinions is to confirm, as I say, the enforceability of their netting arrangements with their counterparties. So regulatory frameworks often require that repos are to be documented under a robust legal agreement, such as the GMRA, and that robust legal agreement like the GMRA should be supported by regularly updated legal opinions. And this compliance is essential to benefit from reduction in credit risk and for capital requirements. As a general rule, ICMA update our legal opinions on an annual basis. The 2025 annual updates are well underway and are on track to be completed in the normal timeline, which is that typically our opinions are dated the 31st of March and are then published in early April. ICMA's legal opinions are a critical resource in supporting the use of the GMRA, supporting regulatory compliance and facilitating efficient market operations, which is, as I say, why we were particularly pleased to be able to add Ghana to our legal opinion library. But with that, I will hand over Richard to go over the practical use of the GMRA, without which, of course, the legal opinions would be irrelevant. Thank you very much, and over to you, Richard.
Thank you, Dina. Welcome, everybody. So I'm going to be taking you through basically the practical use of the GMRA. Let me just call up my slides. And I'm relying on one of my panelist members to confirm that everybody can see this.
We can see it.
Yeah, great. Okay, so...
Oh, yeah, there we go.
Thank you. So that's the title page. The aim today is to deal with the problem people often face when they first have to negotiate a GMRA. So this may or will usually be the first master agreement that many lawyers come across in new markets. It will also be the first master agreement that many front office and back office staff will come across. And it's important that everybody understands the GMRA because it contains not just legal provisions, it also contains operative provisions for how a repo will be governed. And so what we're going to do is going to map the life cycle of a typical repo. We're going to go through the stages of the life of a typical repo and map those to various provisions of the GMRA. So I should say at the beginning that we have less than an hour. So we're not going to cover variation margining, and we're not going to cover default. That can always be done another time. We're going to cover routine business as usual elements. Margining, of course, is a business as usual matter, but it probably won't be too important while the Ghanaian market remains largely short term. So we're going to talk about the architecture of the GMRA, just the overall structure, where things fit. And then we're going to go through these stages. So you can see pre-trade. We're going to talk about Annex 1, which is critical to deciding, to shaping the trades that you're going to do under the GMRA. We're going to talk about the scope of the GMRA and the authority you need to trade under it. And then there's the trading elements, which are matters of execution. We then move to post-trade, and you can see that is the bulk of the agreement. So confirming trades after they've been executed, settling them, dealing with problems with settlement, and then changes in the nature of collateral. This is probably not too important given that this market will mainly be government bonds, but it is possible to use corporate bonds, and they can change their character. There can be corporate events where the nature of the bond or there might be payouts on the bond or a decision to be made about the bond. So we'll cover those. And then collateral income payments, what happens if you're using a security as collateral in a repo and it pays a coupon. We'll then skip to terminating a repo. This will typically be repos done on an open basis where You don't have a maturity date agreed at the start, but it's open to either of the parties to terminate when they feel they need to. And then finally, at the very end, the sort of framework issues. This is a lot of this is boilerplate legal stuff. These are the safeguards that the GMRA, general safeguards the GMRA provides. So in terms of architecture, like other master agreements, the GMRA has 3 levels. If you go to the ICMA website and you download what is the GMRA, what you'll actually get is what's often referred to as the pre-printed form, and you'll also get a blank Annex 1, or Annex 1 without anything filled in. Now, the pre-printed form is it's generic to the repo market. It's trying to encompass the bulk of transactions that take place, and we'll talk about the character of those typical transactions in a minute. If you want to do anything unusual, you have to make amendments to the GMRA. And that brings us to, or amendments to the pre-printed form. That brings us to the next level where we have annexes. And these are starting to tailor the generic GMRA to the type of business you're going to be doing. Now, Annex 1 is pivotal. Any amendments that you must not be made by editing the pre-printed form. That makes it very difficult for people to follow what's being proposed and agreed. So you put everything in Annex 1. Now, there are some amendments which are made quite regularly and are quite standard these days. If you want to do a buy-sell back rather than a repurchase transaction, then you don't have to actually write in your own amendment into Annex 1. You can refer to standardized amendments in the form of buy-sell back annex. If you're going to act as an agent rather than a principal, then you have the agency annex. If you want to use equity, you can use the equity annex and so on. And there are other annexes as well. The only ones that are really relevant to Ghana at this stage are going to be the buy-sell back annex and the agency annex. And then the third level is confirmation. So these are specific to individual transactions. So we have a layer, the pre-printed form, which is general to the market. We have the annexes, which tailor it to the sort of business you're going to be doing. And then we have the confirmations, which are about specific transactions. These are where the economic terms of a deal, the repo rate, the size, the tenor, these are where those are entered, any special terms and conditions applying to a specific transaction. What this means is that everything works from the bottom up. If you put something in the confirmation that contradicts something in an annex or in the pre-printed form, what's in the confirmation will take precedent. What is in the annex that you enable will take precedent over the pre-printed form. So you've got to check things very carefully. Dina talked about legal opinions. They generally cover the pre-printed form and most of the annexes. Now, inside the pre-printed form, we have 21 paragraphs or chapters. The red ones are what I would refer to as largely being operative provisions, the thing you need on a day-to-day basis. The blue ones are generally mainly legal matters, although things like definitions are very important in practical terms as well. We are not doing margin maintenance, so daily valuation and calling of margin, and we're not doing events of default because, well, hopefully you'll never see one of those. There is a proposal to establish an umbrella guarantee facility under TradeClear. If that goes ahead, then margin maintenance and events of default will fall under their control. Now let's deal with Annex 1, dealing with Annex 1. Annex 1 has 2 parts. There is a standard supplemental terms and condition, and these are provisions in that have been left in the preprint blank in the pre-printed form that you then have to make decisions about. We'll have a look at those in a minute, but it's things like what interest rate you're going to apply to cash. So it's up to you to go through that. Now, to some extent, those provisions are provided for you. In the case of Ghana, there is a Ghana Annex 1, and we'll be talking about some of those provisions. But you will still need to go through Annex 1 because there are choices that have been left open to individual counterparties. And then there are a number of standard amendments that you can make. This is where you refer to any annexes that you want to bring in, such as, in the case of Ghana, it will only be the buy-sell back annex or the agency annex. Then if we move to Annex 1 Part 2, this is really about special focused amendments. And there are some standard choices you're given. For example, do you want to, if you've been dealing repo already under another agreement, do you want all those repos to be brought in? Sorry, if you previously used the GMRA, say the 2000 version, do you want all the transactions you did under that previous version brought in under your new 2011 GMRA? There is a provision to deal with the case in which repo rates go negative. Now, that really shouldn't be an issue in Ghana until a market develops where repos are against specific securities. And here, the demand for those securities in the repo market can sometimes force repo rates to go negative, while every other repo rate or interest rate in the market is positive. So a contingency only. If you want to do forward repo, which is allowed under the Ghana Annex 1, then there are amendments that you may want to agree to under these sort of optional amendments. You may decide to opt for some of them. Then finally, transaction and net exposure amendments. These are refining the way you calculate your exposure on individual trades, that's a transaction exposure, and then on your whole portfolio, which is a net exposure. And these then determine the size, or in fact, whether there will be, and the size of any variation margin under the margin maintenance provisions. So you may or may not use these. And then finally, special supplemental terms and conditions. This is where you write in any bespoke provisions that you and your counterparty feel are needed. These should be kept to a minimum because that starts to complicate the GMRA, but it's up to you to decide whether those circumstances, whether circumstances are such that it would be helpful to do this. You can, it's always a good idea to consult legal opinions on this because you don't want to be amending terms and conditions in the GMRA which are core to its functioning. You don't want to jeopardize things like title transfer. So in the legal opinions, they talk about what would be okay to modify, particularly with respect to core provisions and what you shouldn't do. And then finally, a new initiative of ICMA is the clause library and taxonomy. And this provides standard language taken from market practice to fill out some of the questions that you're asked, for example, in Annex 1, Part 1, but also other provisions in the pre-printed form. So you don't need to invent your own language. You can use what's well established in the market. And that, of course, is safer anyway because it's been tested. So this is how it would work. This is before you trade. You're going to have to negotiate your GMRA with your counterparties. So you go through Annex 1, you agree the standard elections that you're required to make. They go into Annex 1, Part 1. You then decide when are any of the optional standard amendments, things like bringing in previous transactions, amendments to transaction and net exposure. And if you do, they go into Annex 1, Part 2. And then you ask, well, do I need to add anything else? Do I need to make any bespoke amendments? And if you do, they go into Annex 1, Part 2. If you can actually use other annexes to do that for you, then you refer to those annexes here. And then, of course, you can fill out anything or many things across the agreement using the clause library and taxonomy. So Annex 1, this is the list of provisions in the sequence in which they are set out. And I put the references there to them, but I've rearranged these into 4 themes. So first of all, there are elections about counterparty and communication. The first thing is designated officers. This probably won't concern you, but if you have several branches dealing repo, some of them would typically be abroad, then you want to bring them all in under the GMRA. This maximizes the effect of netting if your counterparty defaults. So if you're dealing with somebody from Ghana, but also say from a branch in a neighboring country or a country anywhere in the world, then if that counterparty defaults, then all the transactions you've done with them anywhere can be brought into the netting. The practical question, who sends confirmations? Is it you, is it them, or is it both of you? Best practice is, of course, for both of you to send confirmations. Where do you send communications? This is very, very important because you want to make sure that if you serve a notice, for example, the counterparty goes into default and you want to fix the closeout date, you want to make sure this gets through as quickly as possible. Agents for service of process, if you were using the GMRA under English law, so typically cross-border, then you would need to appoint an agent for service of process in an English court. So any transaction you do that is subject to the jurisdiction of English courts, this is part of the civil procedure rules. Within Ghana, this, I believe, would not be relevant. Then second area, do you want to bring in any other annexes to make amendments? So in Ghana, buy sellback annex, agency annex, but there are other things as well. There's something we'll talk about called net paying securities. Do you want to use them as collateral? You have to expressly agree to do that. And are there any other annexes that you might want to use? The third theme is margin and default calculation inputs. We're not actually going to deal with that in this session, but we will refer to a couple of aspects of it. If you do calculations, normal calculations of exposure and for margin calls, and if you do a calculation of how much you're owed if your counterparty defaults, you need a base currency. The Ghana Annex prescribes that this should be the Ghana Cedi, so that's given for you. You can vary this, particularly you might want to do this for cross-border transactions. You might prefer to, for example, use the dollar for margin calculations. Transaction exposure method, again, this is dealt with in the Ghana Annex. You have a choice of two ways of over-collateralizing. So you might be offered certain collateral which you think is relatively illiquid, so you're unwilling to give the full cash value. You can be described as taking a haircut or applying an initial margin. There are different ways of calculating. They do the same thing, but they use different descriptions. So if I gave you 100 of collateral, you only gave me 98 of cash. Okay, that can be described as a 2% haircut, a discount of 2% from the collateral, or it can be described as an initial margin of 2 point something. So a margin over the cash amount. The Ghana Annex prescribes the use of haircuts. Interest rate index and dates on cash margin. If a margin call is made and it's answered in cash, then you will have to pay interest on that on agreed dates. That is covered in the Ghana Annex as well. And then the delivery period for margin, you really want to make sure that it's fully understood if you make a margin call when your counterparty is obliged to satisfy that call. It's usually same day for a domestic market trade with cash margin, but for somebody giving margin as securities, if you're willing to accept margin securities, then it might be 1 or 2 days grace. Then finally, default triggers. Again, we're not dealing with default in this session, but just to note, we'll come to something called condition precedent. So this allows you, if your counterparty goes into default, it allows you to suspend the performance of all obligations to them. And then, will failure to deliver collateral be an event of default? This is quite a contentious provision. It's generally, we don't know for sure, but we have the impression that generally people don't actually apply this provision. There are other ways of dealing with failure to deliver collateral, and we'll talk about some of those. Then finally, something we will talk about is automatic early termination. If somebody goes into default under the agreement, are you happy to wait until you're ready to specify a closeout date, or do you want them to be the closeout date to be fixed immediately? And you might want to do this if there is a danger of the insolvency regime stepping in very quickly in the case of a default, and you want to actually be able to close out a net under the GMRA before the provisions of the insolvency agreement apply, and we'll come back to this. So let's get into the main part. So, this is that series of steps in the life of the repo that we're going to look at. And first of all, what is a repo as far as the GMRA is concerned? And you can see here that in paragraph 1A, it's defined. I blocked out some unnecessary wording. We don't you do this. This is just to simplify the slide. But it basically, as you can see, the seller sells securities for cash to the buyer and a simultaneous agreement to buy them back at a future date. And we see the terms security, we see the terms purchase price and repurchase price and seller and buyer being defined. And then what types of repo are automatically covered by the GMRA? So there are two basic types of repo: repurchase transaction and buy-sell back. And as the Ghana repo guidelines make clear, the only substantive difference between them is what happens if a coupon or dividend or other income is paid on securities being used as collateral. If that occurs, in the case of repurchase transaction, there is a transfer by the buyer. So the buyer will receive a coupon or dividend or other income from the issuer of the security because the buyer is the legal owner, but because the seller is keeping the risk on the collateral, remember the seller has agreed to buy it back at a fixed price, because the seller keeps the risk, they're really economically entitled to that payment, that income payment. So the GMRA provides for an equivalent amount to be paid by the buyer to the seller when the buyer receives a coupon or dividend or other income on collateral securities. And we're going to come back to that equivalent amount. Legally, it isn't just passing the coupon through, it's passing an equivalent payment. And there's good reason why we use that indirect approach. In the case of a buy-sell back, there is no transfer between buyer and seller. We take account of the expected coupon, dividend, or other income by reducing the repurchase price. So instead of the seller getting an income payment from the buyer, the seller pays back less at the maturity of the transaction. Okay, and you can see in the case of buy-sell backs, if you want to use them, which you probably will, then there's provision for you to specify that. And whenever you trade, you say, I'm doing a buy-sell back, and the buy-sell back annex provisions automatically apply. Now, I said at the beginning that the pre-printed form applies to a typical repo, a fairly standard type of repo, the majority we might expect to see in the market. And this is not expressly laid out in the GMRA, but it's implicit. So the GMRA is really designed for short-term repos. If you do longer-term ones, then there are other considerations you need to make, and you may want amendments to cover those issues. It's also assumed that you're dealing with risk-free fixed income securities, so Ghana government bonds, Bank of Ghana bills, that sort of thing. And this means that you don't really need to worry too much about the valuation of that collateral. So there's very little reference, for example, to dispute resolution, because it's assumed these securities will keep their value. It's assumed they're plain vanilla. If you start to use structured securities, say mortgage-backed, again, there are other considerations you would need to make and perhaps amend the agreement. In the case of corporate bonds, if they're simple corporate bonds, they would fulfill this definition. It's also assumed in the GMRA that there is no withholding tax or coupons, and I've referred here to a manufactured payment. I'll come back to that in a minute. But basically, there is very little reference to tax in the GMRA. It's assumed that you get coupons on your underlying collateral without withholding tax, and we'll see later that any payments, it's assumed they're without tax. If there is, in fact, a tax, then you have to decide who's going to take responsibility for it. So we'll be going over that at various points. Now I've come to this point, manufactured payments. So this is the name given by the market to that payment that the buyer makes to the seller when the buyer receives a coupon or dividend or other income from the issuer of a collateral security. So you've given somebody, you've repoed out a government bond. The buyer receives a coupon on that government bond. Okay, they are obliged, if this is a repurchase transaction, they're obliged to make what is called a manufactured payment to the seller. So that's an equivalent payment to what was received as a coupon. Okay, now these are all the name manufactured payment you won't see, but when you see references to income between buyer and seller, this is what it means. Paragraphs 5b and 6b make this statement that as far as the standard agreement is concerned, there should be no withholding tax on coupons or on manufactured payments. So the payment from the issuer to the buyer and from the buyer to the seller. Now, paragraph 5b refers to manufactured payments. So it says, for the avoidance of doubt, references in this paragraph to the amount of any income paid by the issuer of any securities shall be to an amount paid without any withholding tax, withholding or deduction. Oh, sorry, that actually refers to the coupon, I beg your pardon. The next paragraph, 6b, refers to everything else. All money payable by one party to the other in respect of any transaction should be paid free and clear of and without holding or deduction for any taxes and so on. Now, if there are taxes, obviously, these can't apply. So you've got to make a decision. In the case of a withholding tax on a coupon, it's no great problem. You just delete the appropriate provision in the GMRA, allowing the buyer to pass a manufactured payment which takes account of any tax on the coupon to the buyer. If you're doing buy-sell backs, you don't have to worry about any of this at all. But the one lesson we would draw from this is that if you are doing repos, you need to have consulted your tax expert. We talked about designated offices. Remember that these are branches, not subsidiaries, perhaps elsewhere in the country or in another country that you want to include under the GMRA in case your counterparty defaults and you want to include all transactions with them wherever they were executed. And so you would designate those other branches as designated offices. What types of repo? Yeah, now, governing law and jurisdiction. So the GMRA is an English law agreement and it's subject to the exclusive jurisdiction of the English courts. Exclusive jurisdiction is given to avoid the risk that your counterparty, having defaulted, might go to another jurisdiction where they think they might get better treatment. It's to provide certainty of what happens if something goes wrong. Now, there's a bit of confusion in the Ghana repo guidelines. So paragraph 3 about the GMRA says this agreement should be subject to the laws of England. But if you look at the Ghana annex, it's very clear that it's subject to the laws and under the jurisdiction of courts in Ghana. So this would be amended, and it would be amended by using the Ghana annex. What types of repo are not automatically covered by the GMRA? If you want to use repo as collateral, remember the GMRA is really designed for fixed income, for bonds and bills. If you want to use equity, there are other things you have to consider, voting rights, typical withholding tax on dividends, corporate events, and so on. You'd have to amend the agreement, and you do this by using what's called the equity annex, but this isn't included in the list of eligible collateral for Ghana, so we could more or less ignore that. One thing that is also expressly excluded from the GMRA is what are called net paying securities. Now, you might think of a net paying security as one in which the coupon is subject to withholding tax, but in the GMRA, net paying security means something else. Okay, if we illustrate it this way, if you look at the diagram at the bottom, you'll see that the issuer pays a coupon on collateral of 100 and the buyer makes the manufactured payment to the seller. So this is only relevant to repurchase transactions. And in this case, there is a withholding tax taken by the buyer on the manufactured payment and given to the tax authorities. So it's not the coupon that is taxed. I mean, that may be taxed as well. This is what happens in the next step. If that's the case, then the GMRA says, well, no, the buyer is going to have to make up that tax, okay, because it's unfair on the seller. The seller may not be aware of the tax situation of the buyer or of that particular security. So it's up to the buyer to make that good. Now, obviously, the buyer won't be too happy about this. So net paying securities are excluded, and this is to force you to talk to the buyer and make a decision about how the problem is going to be handled, possibly by not using securities where this problem arises. You'll see the definition of net paying securities in the top paragraph, 2HH, and then I've just repeated the question of not deducting tax, and that's 5B. I've also noted down 2Y a definition of income in the GMRA. So this incorporates both coupons, dividends, and other income paid by the issuer on collateral securities, but it also encompasses other payments such as manufactured payments. Oh, yeah, and there I will come back to this later because there's also a complication in the definition. So having understood what sort of repos you can do under the GMRA, what sort of collateral you can use, whether you can automatically use that collateral, you have to make amendments to allow you to do so. You then come to the authority to execute transactions. And this is chapter 9 or paragraph 9 of the GMRA. And you can see that this is representations. So this is a list of things, and I've underlined the key aspects, and you can go through that afterwards. But it's basically ensuring that you are acting at arm's length from your counterparty, that they're not relying on you for any advice, particularly tax advice, that they've got all the authorizations they need, that they're not in violation of any laws, that they are legally able to sign a GMRA and to execute deals under it. They understand the risk they're taking. So if something goes wrong, they can't say, well, actually, we weren't, it's ultra vires, we weren't entitled to do this trade, so we're going to walk away from it. Okay, so it's important that these authorizations are given, and they're deemed to be repeated every time that securities are transferred or a new trade is done. So make sure that you have these representations. You may have to add other ones. So Dina gave a list of the type of institutions that are automatically covered by GMRA legal opinions. If you're dealing with institutions that aren't automatically covered, that might, for example, include pension funds, then you need to perhaps think about getting other representations from them to protect you from an attempt by your counterparty to walk away from loss-making transactions. Now, how do you execute a repo? Sorry, I have a chat question. I'll just see. Yeah, sorry, this is just to remind you to use the Q&A box at the bottom. Thank you, Ludo. So how do you execute it? Well, it's up to you. You can do it in writing or you can just do it over the phone. It's up to you. Now, the GMRA is very precise about what writing means. So picking up the phone, everybody knows what that means. But if I, for example, can I use email? Can I use telex? Can I use fax? Can I use a written letter? So if you go to paragraph 14, then it talks about notices and communications. This will become particularly important in a default because you're going to have to communicate with your counterparty in the legally prescribed way, and this is it. And English courts, for example, are very strict about methods of communication, and Ghanaian courts are as well, I'm sure. So it's in English, it's in writing. What does writing mean? Well, you can see there. Now, as far as trading is concerned, you're probably going to be using either the phone or some form of chat line or some form of email. That's all covered by electronic messaging at the bottom. Executing a repo after you've, well, if you're using the phone, the GMRA provides that the parties can record all their telephone conversations. Now, in some jurisdictions, this conflicts with privacy laws, so you need to check that out. There is no guidance in the Ghana Annex or the repo guidelines about that. I presume it's not an issue. And then what have you agreed to? Well, if you're acting as an agent, which you can under the Ghana Annex, then you need to say so at the beginning before you start trading, that you may be trading as an agent. You don't actually have to, but in case you do think you might, then you say you would be or you may be, and that the agency annex should apply. You could use another annex instead, or not rely on the agency annex, but you've got to make it clear whether you might be acting as an agent. And when you transact, you've got to state that expressly. Okay, when does the transaction, what's the value date? This, of course, is the purchase date in GMRA language. Are you going to be doing a normal value date? So is it going to be T+0 or T+1 or T+2 from the transaction date to the value date? Or are you going to do a transaction that perhaps starts in a week's time or a month's time? So these are forward transactions. They're defined by default in the GMRA as any transaction started with a value date is 3 or more days after the transaction date, but it's up to you to decide whether you want to keep that or have a different period. A lot of people say forwards don't start till T+5. Maturity date, when the repo ends, and the collateral to deliver. In the GMRA, this is referred to as the purchased securities, and it's used, that term is used to distinguish these from the securities that are returned at the end. Okay, so we'll come to those shortly. Cash currency, you can see the provisions there. You can only transact in a freely convertible currency. So that's laid down there. And the purchase price and repurchase price, unless expressly agreed otherwise, must be in the same currency. The amount of cash that the seller receives at the start on the purchase date is specified in 2M, and the repo rate. The GMRA doesn't use terms like repo rate or repo interest because they are suggestive of a secured loan. And we want to make it clear that repo is a buy and sell transaction. So in an attempt to paper over the problem that may be created by terms such as repo rate or repo interest, instead of repo rate, we talk about pricing rate. Repo interest, we call price differential. Then at the end of the trade, the amount of cash that the buyer has to pay back to the seller is the repurchase price. And this, of course, is the sum of the purchase price, the initial cash, plus the repo interest or price differential. I've talked about initial margins and haircuts. The initial margin in the GMRA is called margin ratio. The haircut doesn't have a name, but it is, in fact, a haircut. And you're given the choice of the two, and the Ghana Annex says haircut should be the standard measure. And that's actually more intuitive. I give you collateral of 100, you give me cash of 98. That's a discount of 2%. That's the haircut. And then we, having done the deal, agreed all those terms and agreed that the deal will be executed, we then should confirm it. So this should be done by your back office. There should be segregation of duties between whoever executed the deal and who's ever confirming it. And this is done should be done promptly after a trade, and it's setting out the economic terms of the trade. So you can see there purchase date, repurchase date, the initial cash, the repo rate, all these aspects, whether it's a buy sell back or not, or whether it's an agency trade or not, and any sort of special legal terms and conditions. Maybe you can apply special terms using the confirmation, and it should also include, or that doesn't say that here, it should include details of accounts to be used for settlement. So this is there is a Annex 2 to the GMRA pre-printed form, and this gives you a pro forma confirmation, which you could use, but paragraph 3b is more important because it specifies the minimum that should be included in a confirmation. And confirmations, of course, allow you and your counterparty to check that you both understand the deal that you've done with each other, that it is the same deal, and this is prima facie evidence of the terms and conditions of the deal. And if there's a dispute, unless one of the counterparties has alternative evidence, then this is what will be taken as the record of the deal. Ensuring title transfer. So if we look at paragraph 6E, this basically says that it's up to the parties to ensure that they've taken all necessary measures to ensure that there is a title transfer on the collateral. This is a sale. And there's one exception. If you're keeping your securities with a clearing system or a custodian, they will often take a lien on the collateral you've got there in case you owe them any money. But that shouldn't interfere with the settlement of repo transactions. Now, you then come to settle the trade. And this, if we look at 3C, that says that on the purchase date, this is what happens. The seller gives the purchase securities to the buyer, and the buyer pays the purchase price to the seller. Very straightforward. But this is all assumed to take place on a business day, and that is defined in paragraph 2F. Now, in fact, the definition in the GMRA is very broad, and you can see there that it allows you to use a settlement system or to transact through a bank or some other method. I've crossed out at the bottom references to the Eurozone settlement system, and you should probably do the same. Sorry, that's also, actually, that is done in the Ghana Annex. So this is basically defining a business day as when the settlement system and the payment system is open. Now, in fact, the Ghana Annex defines business day, but unfortunately it gives, or rather the repo guidelines define a business day, but it gives two. It says one in which banking institutions are generally open for the conduct of business in Ghana. And then if you actually look further down in section 7, it says not only when the banks are open, but also when the CSD, the Central Securities Depository, is open. So go with the second one, but make sure that it's included in your GMRA. Settlement of the front leg, cash must be freely convertible. And here, come back to 6B. If there's any tax deducted, it's up to the payer to make that up. Okay, they should know the tax that they're subject to, so it's up to them. This is often referred to as the gross up clause. If there is some agreement between you and your counterparty about how to deal with these sorts of things, you may want to delete this and replace it with something else. Settlement of the front leg, delivery versus payment is what is envisaged by the GMRA, but the repo guidelines, Ghana repo guidelines, also envisage free of payment delivery of collateral, and it's subject to certain conditions that you should fulfill. This rather contradicts with the agreement. The agreement only envisages use of, you can use free of payment, but it's assumed to be an occasional thing. So this should really be amended to, if you are going to be using free of payment. But delivery versus payment is the safe way and should be the standard method. The agreement also envisages that if you owe somebody some money in the same currency and they owe you money in the same currency on the same day, that there will be a netting of payment. And the same, that if there is a transfer of securities, the same security to and from a counterparty, that the delivery should be made net. This is called technical netting. It's merely to reduce the operational burden. It's nothing to do with netting that would take place in a default. And then I have referred to this. This is included in Annex 1, paragraph 6J. If your counterparty goes into default, okay, are you going to do anything about it? You don't have to. It's up to you. You could then trigger closeout netting. That would be chapter 10. But you could simply do nothing. And this is called condition precedent, that you just simply suspend all obligations to the other counterparty until you're ready to, until they are come out of default or you're ready to do something else. This is quite a controversial measure. It's applicable fully under English law, but you need to check whether it is under Ghanaian law and for how long. And then settlement of the end leg, this is the repurchase. And there's a reference here to equivalent securities. So the seller, give you purchase securities at the start, but we talk about you giving me back equivalent securities. This is there for legal reasons. Now, I've crossed out a provision which refers to a security being denominated in euros during the term of a repo. won't concern us. But it gives a definition of what is meant by equivalent. And I don't want to go into detail, but basically it's economically the same, but legally different. So it could be that there is a corporate event affects the security, it changes character, but it's still the same security. So this is to ensure this is necessary, because if the agreement said you have to return precisely the same security to me that I gave you, okay, whereas we're using the word equivalent, which basically means same or similar, okay, if something happens to a security, then, you know, if I sold it to you and you sold it to somebody else and you couldn't buy it back in time to give to me, if you can give me another part of the same issue, okay, then that's fine. It's equivalent. It's economically the same. Okay, but if I said I've delivered security number 100 to you and you've got to return the same, other words, security 100, then that's going to put you in difficulty. And it really means that you probably wouldn't reuse your collateral if you wanted to, which might jeopardize the claim that you've actually bought it and you have full property rights. So if I say the same or similar should be returned, in other words, the equivalent, you can return certificate 105 or 110 to me, and this avoids this problem. If your counterparty fails to deliver, then if the seller is the failing counterparty at the beginning, don't give them any money, or if you do, get the money back. And if you're not particularly bothered, just let the transaction run till the maturity date, because what you'll find is they don't deliver to you, you don't give them any cash, but at the end of the transaction, everything nets out, and they will have to pay you the repo interest for the full period of the repo. If you weren't happy about waiting for this, let's say a 1-week repo and you terminate it on day 3, which you're entitled to do, they would owe you interest on the first 3 days. But if you let it run to day 7, then you'd get the whole 7 days of interest. If the buyer fails to return securities on the repurchase date, then you can just wait for them to do that. Okay, and if there are any coupon payments and this is a repurchase transaction, they have to keep paying them to you. Or you could exercise what's called out in the market, not in the agreement, it's called a mini closeout. This would be to terminate that agreement and value it using default valuation methods, which are quite conservative. But you need to bear in mind that the conservative nature of these valuation methods means that it will hurt your counterparty and they may not want to do any more business with you. So this is a difficult one. There is no easy solution to buyers failing to return securities. But of course, you've got their cash, and after the repurchase date, there's no more interest to be paid on that cash, because repo interest runs up to the repurchase date and is crystallized in the repurchase price. Settlement problems: if somebody hasn't paid cash to you on time, you can charge them interest to the extent you're allowed to by local law, and the interest rate you're going to use is called the applicable rate, and there should be one for default and there should be one for normal problems. So we look at paragraph 2C2 at the bottom. The one you're going to use on just the counterparty hasn't defaulted, but they're late in making interest payment. Then this is a rate agreed by the parties acting in a commercially reasonable manner. Good idea to agree these rates beforehand. Corporate events, we won't spend any time on these. This generally concerns equity and corporate bonds. If there is a corporate event, the security changes character, or some other event happens, a conversion, subdivision, takeover, something like that, then this is how you deal with it. Substitution: if you have given somebody collateral for a period of time and you want it back during the term of the repo, you can ask them and they can refuse or they can agree. If they do give it back to you and you give them new collateral, that's a variation of the contract. The transaction remains in place. There is a peculiarity about the date on which you value a collateral that you're going to substitute. So in paragraph 8A, it says the date of variation. So that's actually the date on which you deliver. This is unusual in valuation of securities. Normally you value on the date you agree to do something. If we look at margin securities, which these paragraphs refer to, they say, yes, it's on the date on which you agree to substitute. So it would be a good idea to use this methodology in the case of all substitutions. And my time is running out, so I better move on. Coupons, dividends, other payments, we've covered this. This is dealt with in paragraph 5A. Remember all the stuff about if tax is levied. And I referred to this income payment date. In some securities, I don't think this is the case in Ghana, there is something called an ex-dividend date. So the coupon is announced, and then perhaps 7 days later, the coupon is paid. So you have an income record date and income payment date. In the case of registered securities, which are typically government securities, it's assumed that the coupon is paid on the income record date. This is to avoid problems with what is called ex-dividend trading, and I'm afraid I'm not going to go into that here. If you had an open repo, well, if you had any repo, you can terminate it early if your counterparty agrees. If you've done an open repo, then your right, the right of both parties, is to terminate when they wish. Okay, and in this case, how much notice do you have to give that you're going to terminate a trade? And it says here in paragraph 2E that not less than the minimum period as is customarily required for the settlement or delivery of money or equivalent securities. So generally speaking, if your securities market takes 1 day to settle, you have to give at least 1 day's notice. Governing law, as I've said, this is supposedly in the GMRA, it's English law, and English courts have exclusive jurisdiction, but that will change in the case of Ghanaian repo. And then if you don't exercise a right under the GMRA, you don't make a margin call when you're entitled to, you don't do something else when you're entitled to, your counterparty may often come back and say, oh, well, you've waived that right for the future. You haven't. Okay, you can only waive your rights in writing and giving due notice. If you deal with a sovereign, then you normally ask them to waive their immunity. They may or may not. If you're going to be doing repo with the Bank of Ghana, I don't suppose they will be. Third-party rights, this is a provision of English contract law. It should be deleted from your GMRA. Single agreement, this is the idea that if netting fails in a default situation, you've basically got this provision which says, look, we did these deals because we assumed we were dealing under a single agreement, that everything we paid or delivered or received was done in consideration of everything else that we had done, or it was a portfolio, not a set of individual trades. That can be quite helpful. It's never been tested, but it's a legal safeguard. Non-assignability, don't give up your rights to obligations under a repo. You want everything to be included together if there is a default and there's closeout netting. So there might be a corporate reorganization of your counterparty and they want to transfer the obligations they owe you to a new entity. Generally be very cautious about doing that. And it's certainly, they can't assume you've done it unless you expressly agree to do so. Tax events, if there's a change in tax law, this doesn't include a change in tax rates. If there's a change in tax law which makes certain repos unprofitable for you or loss-making even, then you have a right to try to terminate it. You have to provide evidence that there is a loss. Your counterparty can refuse because they still need that repo, but in that case, they indemnify you against any relevant losses. It says in the agreement, time is of the essence, a bit like this course, but this is probably unnecessary, but it does no harm to have it because the agreement is usually quite precise about when things must be done, but it's worth including this. Termination, part of the clause we've seen previously, then if you terminate the GMRA with a counterparty, any outstanding transactions that you've got don't have to be wound up. They continue to be governed by the old agreement. Okay, and any remedies, if they fail to perform under the old agreement, they continue in place. And that is it. I think I have a whole series of Q&As. Good morning. Is it possible to see the presentation, the recording? Yes, that has been done. And then in situations where your counterparty varies from the printed GMRA, do you have to explicitly mention how the annex varies from the standard GMRA? No, if you put amendment in the, Dina, please feel free to come in on this. If you amend something in Annex 1, you've amended it. You've amended the pre-printed form.
Agreed.
Thank you. Can you please explain what is meant by equivalent payment? Why not simply pay back the coupon or interest? Okay, so the issuer of collateral securities pays a coupon to the buyer because they're the legal owner. If the buyer said, I'm going to pass the coupon to the seller, then that implies the seller is the legal owner. And so you lose title transfer. So we give it another name. We use terms like manufactured payments or equivalent payments. Assuming I'm dealing with a fund, do I execute with the fund manager or the fund or with the fund on behalf of various funds? Okay, if you're using the agency repo, you will sign it. If you're a dealer, you'll be signing it with the agent, but your counterparty is the underlying fund, and they must tell you how. So they might have 10 funds. They do a repo with you for 100, and they break it up into 10 repos of 10 each. They've got to tell you that they've done 10 with each of these named funds. So you're executing with the fund manager or agent, but the contract is with the underlying fund. I assume Swift messages fall under electronic messaging. Yeah, the GMRA doesn't specify the protocol, whether you use Swift or you use FIX or whatever, as long as the format of the message falls under the legal terms. In an agency repo whose GMRA applies, well, there's only one. You sign a you sign a GMRA with the agent, or if you're the agent, you sign it with a dealer. But it actually here the agent signs on behalf of the underlying funds. There is a single GMRA binding a dealer ultimately with an individual fund. So if you sign up with an agent who's going to transact on behalf of 50 funds, you've signed one GMRA, but that is in effect 50 identical GMRAs. You don't have to sign one for each fund. When settlement for whatever reason fails, do you allow the repo transaction to continue running and accumulate interest at the original repo rate, or does something else need to be adjusted to compensate for the delay? No, the repo has a fixed term, and the repo interest accumulates up to a certain level during that term. Once you go past the repurchase date, the repo is finished. So no more repo interest accrues. So if the buyers failed to return securities, you're keeping their cash and you don't have to pay any more interest on it. If it's the other way round, no, it won't be. That's what you're really worried about, the buyer failing. So remember, repo differs. It is not legally a loan. It is a buy and a sell. Ghana permits Ghanaian law to be used as governing law instead of English law. Well, you're required to if you're dealing in Ghana. Ghanaian law recognises alternative dispute resolution. Yeah. Many people use arbitration. So there is an arbitration provision in the Ghana GMRA. Many people put, if they're dealing cross-border with a GMRA that's covered by English law, they may put in an international arbitration clause if the country of the location of their counterparty is a member of the New York Convention, which is typically the case. So it's a very respectable way of dealing with issues. If the pre-printed form applies to exclusive application of English law and use of English courts, what's the legal basis for prescribing Ghanaian law? Well, you and your counterparties have agreed to do so, and you've consulted the legal opinion, and it says that's not a problem. If the legal opinion library is updated annually, does it mean the typical tenure of a jurisdiction on the library is a year? I don't quite know what that means.
Just jump in there. It doesn't mean that it expires. There's no expiration date, as it were, on a legal opinion. Typically, we update them yearly. There is no hard and fast rule. It's typically, market participant dependent, but we do update them annually.
Thank you. And then the last question, in a case where a security is a net paying security, where do the counterparties record who is responsible for tax payment, the associated tax rate? In the Annex 1, if you anticipate there are going to be legal issues, you want to deal with them expressly, and everything goes into Annex 1. So this is part 2 of Annex 1. So I think we've exhausted the questions. It was a very, oh no, there's one more. Was there a backlash with international banks on the use of Ghanaian law instead of English law in the GMRA? Well, if you deal cross-border, you'll be expected to use English law, and there won't be any problem with Ghanaian law about that. If you're dealing in the domestic market in Ghana, if your counterparty is, for example, the branch of an international bank, they will look at the legal opinion, and if they're comforted, or rather, sorry, they will seek a legal advice on whether Ghanaian law is safe to use in Ghana. And if they are, they will go ahead. And I can't see that there would be a problem, but I don't have to make that decision. Remember, the legal opinion provided by ICMA is on the use of the GMRA under English law, but that's what you'll find cross-border. So if you want a local branch of a foreign bank to use the Ghanaian annex, then they'll go away and ask their lawyers, do you think this works under Ghanaian law? Okay. Now, what I hope is that with the slides and a recording of this, you'll be able to go through the GMRA and say, okay, that clause deals with this issue, and you can see that the GMRA is basically just describing how in legal terms and operational terms a repo should function. Remember, we've excluded variation margin and default management. We may or may not be able to do that in another session. So I'm going to stop there.
Thank you very much, Richard Komoto. This has been an indeed very engaging session. I see all the questions from the participants, and I think you've done well to answer many of them. For us, this is a start in a series of ongoing educational sessions to really promote the use of GMRA to facilitate and make sure we minimize some of the risks that we see in the market. It is a global standard. It is well and tested. And I believe that African capital markets, Ghana, Nigeria, South Africa, and all other places can build our capacity to use these international standard products. From the Ghana side, just to let market participants know, this is not the end of it. We'll be coming up with a handbook and ongoing training sessions for the market. We're also looking forward to going live on the CSD's new system that can address some of the technical challenges the market has in terms of adoption of the GMRA. So these are all things we're working on actively to enhance liquidity and minimize risks in the market. Let me, on behalf of all of us, say a huge, huge, huge thank you to Richard Komoto again. I think he's done an absolutely brilliant job. And wherever you are in the world, please give him a big round of applause. Richard, I hope your ears are ringing with that resounding applause. Thank you for your guidance.
I think people may be going away to have a quick drink, actually, after the rapid review.
I know they are clapping for you. Dina and the team that worked so hard to give Ghana the clean legal opinion, Bella, Bank of Ghana, CSD, our market participants, really, really a big, big thank you. It was exciting for us last year to be the third African country after Mauritius and South Africa to get a clean legal opinion. Dina, the work is not done. We need all of Africa to experience this. And for us, we'll be working with you for the rest of the year to ensure Nigeria, Kenya, all other African markets work and have a plan towards achieving a clean legal opinion on their GMRA annexes. So this is commitment from us at the West Africa or Africa ICMA Regional Committee to deliver more of these enhancements to our market. Finally, ICMA has a big range of educational materials. And so for members on the platform, I encourage you to please reach out to our head of education and continue to benefit from these training programs for your staff. And for members or participants who are not yet ICMA members, I continue to encourage you to join ICMA as members, but even not as members, you can still participate in the very rich group of study documents that they have and training facilities that they have. We'll be reaching out to members to give us guidance on additional training that you need, and we'll be working with ICMA to deliver more relevant training for the market. Finally, for the team that has organized today's meetings, Ludo, and the rest of my GSC team, big thank you to all of you for your hard work. And for the participants, this would not be possible without you devoting your time and asking all the questions that you have. Thank you so much again, everyone, for showing up. And I take this opportunity to wish all of us a fruitful and impactful 2025 with ongoing discussions around deepening our financial and capital markets. Thank you so much, everyone, and we wish everyone a wonderful rest of the day and a blessed moon. Bye-bye.